Thanks, Marcus, for that warm welcome. I hate to be called an expert because I'm sure you're all aware the legal definition of an expert is an ex is a has-been and a spurt's a drip under pressure. So I don't know about that, but in fact I have been practicing for 30 years now. I know I don't look like I have been, but I've been doing fisheries and marine law for 30 years now with Andrew Jackson's, and of course all of that time has been dealing with EU law, CFP law, and now that's all about to change. And I think, as Nigel said, it's probably one of the most exciting, probably one of the most daunting, but exciting times to actually be involved with the fishing industry as we go forward. And at least Brexit, with a 2-year-old child, and I'm going to have to now work into my old age and retirement, Brexit is going to keep food on the table for a while yet. I think the part of this seminar is actually called A Changing Landscape, and indeed I think the landscape changed again overnight with the potential for the transitional period to be extended by another year. We'll see if that actually happens, but this is a very dynamic area to talk about and very difficult to actually pin anything down. So yes, things have changed since we last met 2 years ago, Marcus, but I think the way forward is to maybe just have a quick refresher of the legal position and UNCLOS. We'll then look at the fisheries white paper in a little more detail, and then finally I'll sort of ask the question, what about trade? But I don't want to really steal the thunder or step on the toes of following speakers, but I think we need to look at the trade issues. So, quick refresher for those who can't remember what I said 2 years ago and I'm not sure of the legal position, but as Nigel said, when we come out of the EU, then we fall out of the Common Fisheries Policy and we fall under the ambit of UNCLOS, which is the United Nations Convention on the Law of the Sea. And as it's said in that white paper, and as Nigel said, the UK becomes an independent coastal state, and that's for the first time in 40 years. So we have control of our own waters. Now, what are our own waters? There are various limits. Our territorial waters are out to our 12-mile limit, but then we also have what's called an EEZ, an exclusive economic zone, out to the 200-mile limit. But of course, in certain areas, if we go out 200 miles, then we are already into the waters of other states, or probably halfway to Paris in the case of the Channel. So what we have down those areas where we can't go out to 200 miles is a median line. So everything that falls inside 200 miles or the median line becomes UK waters and comes under our exclusive control. And as a result, the UK can take a share catch equivalent to the actual resources in its own waters. Now, under UNCLOS, there is an obligation for us as a coastal state to set a maximum sustainable yield, and that's where the points that Nigel was saying about sustainability come in. We must set a maximum sustainable yield. We are required to do that, but it is within our gift to decide what that maximum sustainable yield is. But also there are other obligations on us, and that includes the obligations to share any excess of that maximum sustainable yield that we cannot properly harvest with those other states who have a historical right of fishery in our waters, and I think that would include those other members of the EU who have traditionally fished in our waters. So it will be a case of us having to enter into the negotiations to share the excess fish which we cannot deal with and we cannot harvest with our European neighbours. Now, in the meantime, we've got alignment with the EU, so as at March next year, as Nigel said, things will continue. We've got alignment, so fisheries legislation, etc. will continue, and at the present time we have alignment until 2020. From 2021, access to our waters and access to EU waters by British vessels will be a matter for negotiation. Now, I know that caused an awful lot of political upset and discussion within the fishing industry when that transitional period was announced. There was a certain view that the fishing industry would be sold down the river. We would, of course, during that period be subject to EU quotas, but of course we wouldn't be at the table to set those quotas. Now, I can only imagine what will be going on in the press and what we'll be saying in the press and what's being said on television just at this moment from the fishing industry, with the view that that may extend for a further year yet. And of course we can all take our views as to whether that politically will be acceptable. I understand it will require a government vote, a parliamentary vote, and we can all probably guess where that may go. So as I say, this whole issue is very dynamic, but at the present time, from 2021, foreign access to UK waters and UK access to EU waters and other third party states will be a matter for negotiation. There we go. So if I can turn to the Fisheries White Paper and apologise for those who've read this line by line and who've put their consultations in. But the consultation response has now closed. The White Paper was published in July 2018, as we heard from Nigel. We're about to receive the government's response to that, and I understand, speaking off the record with a government lawyer last week, that the White Paper is quite likely to be published possibly this year and maybe not too far away. So what did the White Paper cover? Now I can only summarise it. It's a rather chunky document, but first of all, one of the things that the catching sector has always been upset about is it looks as though we may have an end to relative stability. Some of you may not know what that is, but basically the situation is that when we negotiate our quota each year with the EU, the amounts or the proportions are kept the same, so there is relative stability based on historical catches between the years 1973 to 1978. Now obviously that probably now does not reflect the true nature of the fish in UK waters, and therefore the UK will, under the Fisheries White Paper, look towards a system known as zonal attachment, which is effectively an analysis of the fish that is in UK waters and a more favourable and more equitable division of our stocks between the UK and other countries. There's also much emphasis on the position of annual exchanges and multi-annual agreements. So hopefully, in terms of multi-annual agreements, we won't be negotiating on an annual basis. We'll be able to set multi-annual agreements with certain states, member states. We'll be looking at exchanges which are in our favour in terms of obtaining access to stocks that we want, which are outside UK waters. And up to now, in terms of regional fisheries management organisations, the UK has operated under the auspices of the EU. The EU has always gone to meetings on our part and negotiated on our part. So the UK, once it comes out of the EU after Brexit, will take its own independent seat at regional management organisations such as, for example, NIAF, which is the North East Atlantic Fisheries Commission. So we will have a seat at the table and we'll be able to negotiate. So, of course, one of the issues that was very much discussed about with the fishing industry was the question of, do we gain extra quota from Brexit? Then the White Paper covers this as well. The White Paper interestingly accepts that the right to fish is a public asset. However, fixed quota allocations, which is the basis on which current quota is allocated, will continue for existing quota. Now, my view on that is that this is because it has already been well established in law that quota, although it is still officially distributed at the discretion of the minister, does attract property rights. A leading case in the High Court established that quota, and I suspect it would be regarded as licences as well, are property for the purposes of Article 1, Protocol 1 of the European Convention on Human Rights. So those quotas cannot be taken off holders if they are being utilised. They cannot be taken away without compensation. And of course, European Convention on Human Rights is nothing to do with the EU. It's not a Brexit issue. The European Convention will survive Brexit. It's an international convention, nothing to do with the EU. Also, the courts have held that quota and licences are property rights for the purposes of the Insolvency Act. So in an insolvency situation, the courts regard quota and licences as property. And much to the disappointment of many a fisherman, the courts have also held that quota and fisheries rights and licences do constitute matrimonial property, and therefore can be taken into account in divorce and family proceedings. So quota and existing licences are very much part of the English law, English legal situation, and I don't think the government has the appetite or the finances to take a legal battle on that. So that's why fixed quota allocations, I think, will continue in their existing form. But there will be a surplus that we gain as a result of Brexit, and what the white paper says is that that will be put into a quota reserve, that it may be used to incentivise the reduction of discards, so the government will have quota at its disposal to assist with regard to the issue of discards. There is also the prospect of auctioning stocks on an annual basis to raise funds, which could then be applied within the fishing industry for such matters as research or possibly safety issues. And then interestingly, there is also the suggestion of a reserve of stocks to allow for recreational fishing, and a recognition that recreational fishing takes a considerable amount of quota, or a certain amount of quota, out of the seas, and therefore we might see recreational fishing attracting or being able to use some of that additional quota. Turning to revisions of fisheries management, what does the white paper say? Well, obviously at the moment we have bodies called producer organisations. They are a European beast. They are formed under European law. The white paper says that they will be replicated under UK law, and therefore they will continue their role in fisheries management. What the white paper also says is that we will try to derive maximum benefit, and that should be from economic link vessels. So as I predicted, I think 2 years ago, we will see tighter restrictions on flagships. We won't see the end of flagships because, again, flagships own quota, own licences, and we're back to the problem of property rights. But what we will see, and what I'm pleased I did predict, was that we will see closer links with those flagships and a move to derive maximum benefit from them. We'll also see varied and flexible use of effort. So I think there'll be greater use of effort days at sea. We'll also see electronic vessel monitoring. We saw, I think, in Fishing News last week that the under 10s are looking at VMS, but we will see greater use of electronic vessel monitoring, and I think that's important again from the perspective of fisheries management and fisheries enforcement. We, of course, when we take back all of this water, we will be solely responsible for policing those waters. We, quite frankly, haven't got the resources to do that with our current surface fleet, and therefore we will be very heavily reliant, I think, on electronic monitoring. But that, again, brings with it a number of issues which will have to be resolved. I was involved in the periphery of a recent case which was brought before the courts based exclusively on electronic vessel monitoring evidence, and which failed in the courts, because at the end of the day, whilst the satellite can tell you where a vessel is, what course it's doing, what speed it's doing, it can't tell you whether it's fishing, and on that basis that case failed. So there will have to be further work on electronic vessel monitoring, but we will see that. And then perhaps most importantly, we will see a review of the current under 10 metre fleet. It is a very artificial, I feel, division within the UK fleet. The under 10 metre segment has caused an awful lot of problems within the industry in terms of its uptake. The history is long and varied, but basically what happened was we had an under 10 metre fleet which was not subject to strict regulation. Its actual capacity and catch capacity, I think, was either grossly underestimated or, to a degree, ignored until, of course, the introduction of registered buyers and sellers, which revealed its true capacity. And now that under 10 metre fleet needs feeding with quota, and that is a big difficulty for us. And of course Brexit does give us the opportunity to feed that requirement for quota for that fleet, but it also gives us the opportunity under the fisheries white paper to restructure the fleet to see if we can actually end that rather artificial division in our fleet. Moving to trade, then I think this is a key issue for the industry, whether you are in the catching sector or in the processing sector. And I think it's reassuring that the government, as we've heard from Nigel, is still very firm on this point, and it is in the white paper. And I've actually put a quote there in the from the white paper. Access to markets for fishery products will be agreed as part of our future economic partnership, just as with other goods and products. This is separate to the question of fishing opportunities and access to waters, which will be addressed separately, founded on the UK's status as an independent coastal state. And I have to say, I think that is an absolute vital definition, or a vital issue for both parts of our industry, whether you are in the catching sector or the seafood processing, etc. sector. And it's good to see that there will be no linkage. There's been an awful lot of concern that linkage will be sold for fishery rights, etc. The two will be linked, and it is good to hear that remains a key aspect of government policy. When it comes to discussing trade, there are others who are coming after me, so I don't want to step on their toes. And in any event, trade at the moment, the way the negotiations are going, you might as well actually have a crystal ball here in front of you rather than me speaking to you. It's a very difficult and very dynamic way forward. But I think the areas to watch out for are the Pan-European Mediterranean Convention. I think that is being looked at as a potential way forward in trade issues. That's a convention or a trading agreement at the present in which the UK participates, but as a member of the EU, and it may well be that we will become a member in our own right within that trading organisation, which will assist with regard to trade issues and issues of origin. As I've put on there, the issue of trade is probably the most contentious given the complications of the Irish border. I think fisheries was one of those contentious areas, and certainly one of the areas that attracted a lot of headlines with the flotilla down the Thames, etc., etc. But of course the Irish border has really pushed fisheries into the background, and that might actually be a good thing for us, because it might allow proper negotiations in respect of fisheries. I think the resolution of trade is likely to be the make or break issue in respect of Brexit. I think we all agree with that. And of course, as we've heard, if we end up with no deal on fisheries, then we are back to the WTO rules. And again, I'm not going to stand on other people's toes and discuss that here. So that is actually quite a very brief run through Brexit. From a legal perspective, I'm very happy to answer questions on it. I've probably taken well under my 20 minutes, but that's the way it stands at the moment. It could all change, of course, by lunchtime. It could all change with a new government by Christmas. Who knows? So as I say, a very dynamic area and a very difficult time to be a lawyer, because as you all know, lawyers like to be black or white. And at the moment, there's an awful lot of grey out there. So thank you very much, Marcus.